Hello, everyone. Um, Welcome to today's webinar on climate litigation. My name is Cynthia Okello, and I'll be today's moderator and sort of the host of this webinar. So we will start in a few minutes. So we're just giving people a chance to join, maybe at 2 or 5.
Conference.
Hello, Lambert. Thank you for joining. Uh, so yeah, we'll start in the next 3 minutes. We'll just there's interpretation available in this call. You just click on the button on more, and then you'll see interpretation available in French and in English. So we'll start in the next few minutes.
Yes, good morning, John Cynthia.
Hello, Richard. We were actually waiting for you.
Yeah, I'm here. Sorry, I'm coming from the hearing. That's why I was rushing the time, and I left one colleague who also is ending this conference. Is all also getting out in short minutes.
That's okay. So we're going to start in 2 minutes. So we're just waiting for people to keep joining, and then we can start.
No problem. I'm there for that. Thank you.
Thank you.
Yeah.
Okay, good afternoon, everyone. Morning, good afternoon, depending on where you are. My name is Cynthia Okello from the Pan-African Lawyers Union. I'm an economic governance officer, and I lead the climate justice portfolio at PALU. I can see people are introducing themselves in the chat. Welcome, everyone. I can see Ali, Shadrach, Abubakar Fall. We are happy to see you. Maxamud, Peo, Alan Collins, Fernand from Cameroon, Faith Masharia, happy to see you from Anjarwala and Kana. David Ndungu, Richard Bishalanga. Thank you all for joining us today. We're really happy to have you once again on our capacity building session. And this one is specifically on climate litigation. Just to let you know that we have interpretation for all our French speakers. So we have French to English, English to French translation. You click on the button written more, and then you'll find interpretation right there. Today we have our chairperson for the Environmental Law Committee, our very committed Mr. Richard Bishalanga Ilunga. We're so happy to have you. We also have three speakers today, only that one will not be speaking directly to us. He has sent a video, which we shall be playing. So I will allow Mr. Richard Bishalanga to give some opening remarks in 5 minutes, and then I'll introduce the speakers, and then we can start our session today. So, Mr. Richard Bishalanga, the floor is yours.
Merci beaucoup, Madame John Cynthia.
Thank you. Thank you, Madam June Cynthia, for this opportunity you are giving to us. So before my opening remark, I would like to start by thanking the Secretary General for the work they are doing in order for our commission to organize this webinar. So this being said, dear panelists, distinguished participants, all protocol duly observed. Good morning. So while waiting the results of the advisory brief of the African Court of Human and People Rights, it was on the May 2nd, 2025, in collaboration with a collective of some organization of the civil society, Climate Platform, National Justice, Environmental Lawyers Collective for Africa. So it's important to note that this will not be the first work on climate change and human rights, because three briefs were already shared by other jurisdictions have and on greenhouse gases, which is a really important issue. The tribunal or the court also shared a brief on the 21st of May 2024, asking the states to be more diligent, and by this obligation, the states should take necessary measures in order to cope with the issue and in order to protect oceans. The second obligation is the assistance to vulnerable states. We are waiting for some assistance for vulnerable states, especially against the increasing level of waters. We also have the American courts in its brief published in 2025, because this brief took into account the emergency of the climatic issue, and it was asking us to make sure women and other humans are also protected. So we cannot go into the details because I know the panelists will come back on it. The third jurisdiction is the uh, International Court of Justice, and they, of course, worked with the National Assembly of the United Nations. They were working on the climate treaty. It's important because the obligation is threefolded. We have responsibility towards the small island states, and this issue is also important for us, and we are called upon to reflect together on the trends, the the key trends in Africa and see how to dissect the various issues and formulate some recommendations to the policymakers, some organization of the civil society, and in order for all our discussions that will be held today to be taken into account, and we will be able together to have an advocacy brief in order to map the climate issues in Africa. So this being said, on behalf of all the members of the Environment Commission and on my own behalf, I declare this meeting open. Thank you.
Thank you so much, Richard. It's always a pleasure to have you with us. Thank you so much for that. Indeed, I'm seeing people are also just providing greetings. I'd like to also recognize our former president, Mr. Karu Abdul Bagui. Welcome so much. Thank you so much for joining us. And also, if you have any questions, please remember to use you can either use the chat or the Q&A section. So there's a place where there's more, there's a toggle button written more. And then when you click on that, there's a Q&A section where you can pose all your questions that you have as the webinar goes on. Yeah, thank you all for joining. So at this juncture, I'll introduce our panelists today, and then I'll quickly hand it over to the first speaker to take us through. So our first speaker, who's going to be our main speaker, is Dr. Rumbidzai Wendy Muzangaza. And I really hope I have not butchered your name. She's our lead speaker. She's an expert in climate change law and environmental, human rights, and urban climate change governance. Ms. Wendy Muzangaza is a postdoctoral research fellow at the South African Research Chair in Cities, Law and Environmental Sustainability, CLES, at Northwest University. She specializes in climate change law, climate litigation, environmental human rights, and urban climate governance. At CLES, her work is framed within the overarching theme of city-level climate change governance, including litigation, from an African regional perspective. She serves as co-editor of the Potchefstroom, I hope I haven't butchered that, electronic law journal, and is a member of the South Africa expert group of the British Institute of International and Comparative Laws Global Toolbox on Corporate Climate Litigation. She's also engaged as an expert in the presidency's comprehensive South African climate plan project, supporting national climate policy development. So that is going to be our first speaker. And quickly, I'll just introduce the other speakers and then I'll hand it over. So our second speaker, who is not going to be able to join us, but has shared his presentation with us, is Mr. Ayman Chekawi from Morocco. He's the director of the Hassan II International Center for Environmental Training, the academic arm of the Mohammed IV Foundation for Environmental Protection. He also serves as coordinator of the Mohammed IV Prize for Climate and Sustainable Development, deputy chair of the IUCN World Commission on Environmental Law, and lead counsel for climate change at the Center for International Sustainable Development Law. So our last speaker will be Mr. Lambert Husseini, who holds a bachelor's degree equivalent to a master's degree in economic and social law, awarded by the University Institute of Congo in Lubumbashi, DRC in 2019. He has been a lawyer since 2023 and is a partner at law firm of Bar President Didi Kingagala, Ebondo Mining Attorneys. He has been a member of the National Bar Association of the DRC and the East Africa Law Society and also the Pan-African Lawyers Union under the Environmental Law Committee. He actively participates in training sessions and conferences in Europe and Africa each year, which has benefited from extensive training in environmental law, mining law, domestic and international arbitration, and human rights law. So thank you so much, panelists, for joining us today. Thank you for making the time. So quickly, we'll just go into the first presentation where Miss Wendy Muzangaza. I hope you can hear me. We can't hear you.
Yes, I can hear you.
Oh, thank you so much. So, from your African perspective, kindly just tell us how climate change litigation has evolved and what role it's playing in advancing environmental human rights. And as you do that, just maybe you can touch on the key legal implications from your view of the ICJ advisory opinion. What gaps or additions do you anticipate the African Court advisory opinion will address? And finally, like the cases or legal strategies that African lawyers can prioritize going forward, looking at all this. Over to you, Wendy.
Good afternoon. Am I audible?
Yes, you're audible.
All right. Thank you very much. Good afternoon, and thank you very much to Palu for this invitation. It is a privilege to join this discussion at this important time. My remarks this afternoon mainly draw from my research, my doctoral research on climate litigation in Africa and environmental human rights, the ICJ advisory opinion, and more recent African climate cases. I feel very privileged to be among lawyers today, a different arena for me because I'm mostly in the academic space. But yeah, thank you so much for the invitation. Let me begin with the first question, which asks how climate litigation has evolved from an African perspective. So the first point that I would like to make is that the African climate litigation story is not one of absence, but it is one of under-recognition. Global scholarship has often been shaped by global north assumptions about what counts as climate litigation. So as a result, sometimes these cases, the African cases, have appeared sparse or atypical even where they are deeply climate relevant. So many of them are not purely framed as climate change cases, as you would have it. They are often brought as EIA cases, public participation, pollution, admin law, or constitutional environmental right cases. Yet they still deal with climate governance, climate risk, environmental justice, adaptation, and so forth. So this is why, although the numbers are useful, they do not tell the whole story. It is a matter of how these cases are framed and what they're trying to achieve. So I would say climate change litigation in Africa has evolved in three broad phases. I'm not sure if, Cynthia, you're going to share my slides or if I should just continue.
So I'm sharing my screen. I don't know if you can see it.
Oh, okay.
Are you able to see it?
Not from my end. I'm not sure if others can see it.
Mm. You can't see it? I'm seeing thumbs up. People can see it.
Okay, if people can see it, then it's fine. Maybe it's because I'm seeing myself, but anyway, it's okay. As I was saying, I would say African climate litigation has evolved in three broad phases. So the first phase was relative absence, where climate-related harms were present, but not commonly framed as climate litigation. So these environmental disputes, they presented as pollution cases, admin law disputes, or general environmental governance matters. Then the second phase was indirect emergence, where climate disputes developed through public participation, EIA, access to information, and environmental authorization challenges. So this is important because African climate litigation is often entered through the procedural door, which is public participation, EIAs, access to information, and that patterns remains a defining feature of the field. And then the third phase, which we currently are in now, is one of growing rights-based accountability, where the courts are increasingly being asked to review government decisions, challenge fossil fuel projects, ensure meaningful participation, and hold public and private actors accountable for environmental harm. So even though the African climate litigation terrain is still limited and uneven, it is growing. And to show this evolution, I'll just briefly run through some case examples. For example, if we look at Kenya, the Save Lamu case, which is the most popular one, established that climate impacts and meaningful participation must form part of environmental assessment. And then the Menengai West case and Greenbelt movement, these cases are all on the Sabin Center for Climate Litigation website, so you can go and look at them. These two cases that I just mentioned, they then extended this logic into geothermal and transport infrastructure by insisting on proper climate assessment before project implementation. And then in the Collins Sang case, it confirmed that large-scale energy planning decisions can raise constitutional concerns about transparency, participation, and sustainability. And then there are other cases like the Osban case, which broadened the field by further showing that conservation and carbon-related land interventions may also generate climate-relevant rights disputes. So together, these cases from Kenya, they show a shift from procedural environmental review towards wider rights-based climate accountability. We could also look at South Africa, which shows a similar but more mature trajectory. With the Thabameti case, which is the most popular one in South Africa, again, it established that climate change is a relevant consideration in environmental authorization. And then the Wild Coast case and Shell litigation, they then expanded climate litigation beyond emissions and permits into indigenous rights, culture, consultation, and constitutional dignity. There's also the Tugela shareholder case, which pushed climate litigation into the boardroom by treating climate accountability as a question of company law, transparency, and shareholder democracy. So these cases, I'm just going to give a few examples, but they show that the field is moving beyond project-specific review towards broader consultation and governance scrutiny of fossil fuel futures. We also have cases from Nigeria. We also have cases from Zambia, Namibia, and Uganda, which add further dimensions to these, but for the sake of time, I'm not going to go through them now. If any questions arise later on, I will respond to them as they come. So the second part of the question asks, what role then is climate litigation in Africa playing in advancing environmental human rights? And I would say it's significantly an accountability role that it is playing in advancing environmental human rights. So first, it is translating these broad rights that we have into concrete state duties by connecting the rights such as the right to life, health, dignity, and a clean and healthy environment to climate-related harms such as pollution, flooding, and droughts. Second, it is making public participation and access to information enforceable by requiring governments and corporations to consult affected communities properly, disclose key environment and climate information, and justify their decisions transparently. Third, I would say it is forcing institutions to adopt climate literate decision making by requiring environmental assessment, licensing systems, and regulatory decisions to consider climate long-term emissions, future generations, and vulnerability. It is also expanding the protection for vulnerable groups, especially children, indigenous communities, and women, as well as displaced people who bear the disproportionate climate burdens. In this way, climate litigation then is helping to reframe climate change in Africa as a human rights issue, not merely as an environmental or a policy issue. This brings me then to the second question, which looks at which is asking rather, what are the key legal implications of the ICJ opinion, and what gaps or additions do I anticipate, or do we anticipate the African Court Advisory Opinion will address? So as you can see from the slide, I'm not going to go through what the ICJ Advisory Opinion has said. It is basically the information that is there on the slide, but it raises major legal implications. It raises the normative status of climate obligations, widens the legal basis for climate claims, and makes future climate litigation harder for states to dismiss as merely political. So looking at the key implications, I would say first, it means climate obligations can no longer be treated as soft commitments only. By locating the duties across climate treaties, customary international law, environmental law, and human rights law, the opinion is strengthening the argument that inadequate climate action may amount to a breach of law, not simply weak policy. So this has a major implication for litigation because claimants can now rely on a broader and more authoritative legal foundation. Second, it makes it harder for the states to argue that climate action is entirely a matter of national discretion because the court's treatment of due diligence, best efforts, and the limited discretion surrounding NDCs implies then that states must now justify their climate conduct against legal standards of reasonableness, care, and adequacy. Third, it gives stronger support to rights-based climate litigation by linking climate harm to human rights and treats environmental protection as a precondition for the enjoyment of those rights. Fourth, I would say it strengthens the legal importance of adaptation, not just mitigation, meaning states may face greater legal pressure not only to reduce emissions, but also to protect people from foreseeable climate harm such as floods and droughts, for example. There are also other implications, but a further implications that I might just add is that it also strengthens the legal pressure against continued fossil fuel expansion because new fossil fuel licensing, subsidizing, or enabling activity in Africa will now be more vulnerable to legal and political challenge. But the ICJ opinion is also cautious, though it's strong on clarification, due diligence, prevention, and cooperation. It is restrained on distributive justice, burden sharing, historical responsibility, and the practical architecture of climate justice. So this is precisely where the African Court then can add something vital, which brings me to the second part of the question, which the courts must acknowledge that the African Court must acknowledge that climate litigation in Africa must be understood within the context of specific realities, which are disproportionate climate vulnerability, low historical emissions, uneven state capacity, our histories with colonization, development pressures, extractive economies, poverty, and deep socioeconomic inequality. In this context, then, litigation in Africa won't simply about the environmental protection, but about the protection of life, dignity, health, livelihoods, land, water, cultures, and the rights of present and future generations. So the African Court should not merely repeat what the ICJ said, it should interpret these obligations through Africa's own architecture, our own lived realities, and justice concerns. And it can do this by placing Article 24 at the center. As we know, African 24 protects the rights of all peoples to a general satisfactory environment favorable to development. I think this is a uniquely powerful position because climate change is collective, it is developmental and intergenerational all at once. And it has to also interpret Article 24 together with the rights to life, health, dignity, equality, and other rights, because climate harm affects the entire architect of human and people's rights, and make clear that these climate obligations are both substantive as well as procedural. It can also adopt a pro-rights interpretation of the wider African human rights architecture. And it must be clear here that, the states have additional obligations towards those who are most vulnerable, and that climate obligations are not neutral or abstract. They must be interpreted through vulnerability, inequality, and differentiated impact. It can also address corporate accountability and natural resource governance in more explicit regional terms. So the court can clarify the duties regarding multinational corporations, environmental defenders, participation and decolonization of natural resource governance. So this is important because much of Africa's climate injustice is linked to external actors. resource extraction, carbon offset projects, and weak domestic regulatory systems. Finally, it can also be clearer than the ICJ on climate justice as distributive justice, including support obligations, differentiated vulnerability, and the unfair shifting of burdens onto poor and marginalized communities. This brings me to the third and final question, which is what type of cases or legal strategies should African lawyers prioritize going forward? I think my simple answer, not being a lawyer, would be that African lawyers should prioritize better framed, more strategic, and more evidence-rich cases, rather than having a goal to just simply produce or have more cases. So from my research, prioritizing EIA and permitting litigation works because climate literate impact assessment remains one of the strongest doctrinal entry points in Africa, as we can see from the Save Lamu case in Kenya or from the Tabamete case in South Africa, for example. Second, I think they should bring more adaptation and disaster governance cases, especially around floods, landslides, and displacements, as well as resettlement, as we can see in the Tsama Williams case and Aiton petition cases. Third, I think they should develop children's rights, future generations, and public trust litigation. They should also increasingly pursue corporate accountability litigation, which includes divestment and asset transfer scrutiny, methane and gas flaring enforcement, shareholder climate governance claims, and greenwashing challenges. They should also bring more implementation litigation because climate statutes, funds, registers, and monitoring systems mean little if they remain dormant. They should also take procedure and evidence much more seriously because if anything, the Namibian and Ugandan cases have shown us is that, even strong right claims can fail because of forum choice, exhaustion of internal remedies, agency defects, or evidentiary weaknesses. And then I think they should think also in terms of litigation plus, which is litigation combined with research, community mobilization, advocacy, pressure, investor pressure, and regulatory engagement. The South African example of the life after coal reminds us that climate litigation is most effective if it is combined with research, economic modeling, community mobilization, advocacy, investor pressure, and regulatory engagement. Then methodologically, I think African lawyers should plead environmental human rights explicitly. And this was one of my core findings from my doctoral research, is that environmental human rights are not being pleaded explicitly. And you can't expect maybe the court to make those arguments for you. They should be explicitly pleaded, and they should combine substantive and procedural claims so that we avoid mechanisms like the EIA rather becoming a box ticking exercise. They should also make fuller use of climate science and litigate with implementation in mind. So the remedies that we seek should not only stop at declarations alone. They should seek monitoring, disclosure, revised assessment, stronger institutional obligations, and where appropriate, compensation and guarantees of non-repetition. So they should connect litigation then to broader advocacy and law reform. This brings me to my conclusion, and I would conclude by saying climate litigation in Africa is no longer peripheral or experimental. It is an increasingly sophisticated practice of public accountability. But more importantly, it is developing on African terms. Across the continent, climate litigation is not limited to classic mitigation claims as we would see in the global north or standalone emission disputes. It is emerging through environmental impact assessment challenges, public participation claims, adaptation failures, disaster governance omissions, fossil fuel and energy planning disputes, corporate accountability, access to information cases, community land conflicts, and public trust claims that are being brought on behalf of children and future generations. So in that sense, African climate litigation is revealing itself as procedural, as rights-based, adaptation sensitive, community-centered, and deeply shared by vulnerability and justice. So while the ICJ has given the field a stronger global legal foundation, the African Court still has an important and distinctive, or rather transformative as well, role to play. It can build on that global foundation while articulating a jurisprudence that speaks more directly to African realities, one that is anchored, albeit not entirely, in Article 24 of the African Charter, one that foregrounds people's rights, centers vulnerability and intergenerational justice, strengthens participation and accountability, and addresses adaptation, displacement, land, corporate power, and distributive climate injustice more explicitly than the global forums have done so far. For African lawyers, the task then is simply not to bring more climate cases, as I've previously mentioned, but to bring the right cases in the right forums with the right supported evidence and with remedies capable of changing governance in practice, not just on paper. This means stronger rights framing, more strategic use of climate science, greater procedural discipline, closer attention to implementation, and a wider understanding of climate justice itself. So the challenge now is no longer whether climate litigation matters in Africa. It does. That has been established. The challenge is whether we build it boldly enough, carefully enough, and strategically enough to meet the scale of the climate injustice that is confronting the continent. Thank you very much.
Oh, thank you so much, Wendy. That was really a lot. Thank you so much for sharing. And I love the fact that you said that environmental human rights should be explicitly pleaded. I think that's one thing that really comes out clearly when you look at the pattern in climate or environmental litigation, stroke climate litigation. Usually, some of the issues come out in litigation related to land or other disputes, but not specifically environmental rights. And I love that you brought that out. No one would actually think you're not a lawyer. You did really well. Thank you so much.
Thank you.
Thank you so much. So, right now we're just going to move on swiftly to our next speaker, who was not able to join us due to competing priorities, but we will be playing a video he shared of his presentation. So I'll hand it over to our technical team to share it. Please keep asking your questions in the Q&A, or if you're not able to access it, you can ask in the chat and we'll try as much as possible to respond to all the questions. So as we wait for the video, I can see there's one hand raised and there's one question in the Q&A. If you're also able to unmute at the end of the presentations, we'll allow you to unmute and also to speak. So just phrase your questions and keep them close. And then at the end, we'll have some time for the Q&A. So technical team, IT team, please play the video. Okay. So, as we wait for that, then we'll just move on to Mr. Lambert Useni, who is a member of our environmental law committee and also an environmental law expert from DRC. Lambert, can you hear me?
Ok, merci beaucoup, madame.
Thank
Moi,
you
je
very
m'exprime
much,
en
ma'am.
français.
I
Je
will
ne sais
speak
pas
in
si vous me
French. I
saisissez.
don't know whether you can follow me.
Yes, we can follow you. So I'll just quickly ask the question that you're going to respond to, and then we continue the discussion from there. So kindly, Lambert, from your experience in the DRC, what do you think are the main environmental and climate-related legal challenges currently facing your country specifically, and to what extent is climate litigation being used as a tool for accountability in your country, and what barriers do lawyers face in bringing environmental or climate-related cases at the national level?
Merci beaucoup, madame.
Thank you very much,
Merci
madam.
beaucoup à tous les intervenants.
Thank you very
Merci,
much to all the
madame le
speakers. Thank
modérateur.
you, Madam
Et
Moderator.
salue aussi toutes les
I would
personnes qui
like
me
to greet
suivent,
all the persons who are following me,
les participants
all
aussi. Je
participants,
remercie
and I would like to thank
les présidents des
the
PALU,
President of
panafricaine des
PALU,
avocats.
the
Et je voudrais
Lawyers
par la même
Pan-African
occasion
Union. Also, I
intervenir
would like to take this
à
opportunity
l'obligation de la
to
République démocratique du
talk
Congo
about
face
the
au changement
obligation
climatique,
of the DRC
qui est un
facing the
problème
climate
majeur
change.
chez nous
In
ici
fact,
en
we have a
RDC.
major challenge in the
Et la
DRC,
question qui m'a été
and the
donnée, c'est
question
d'après mon
asked
expérience en
is
tant
that
qu'avocat
from my experience as
et
a
juriste en
jurist
République démocratique
and
du Congo,
lawyer in the DRC,
quels sont les principaux
what
défis
are
juridiques
the
liés à l'environnement
key
et au climat auxquels
challenges, legal
notre pays est
and
actuellement confronté?
environmental challenges, and what are the
D'après mon
challenges facing
expérience,
our country? Based on my experience,
oui, vous me suivez?
are you following me?
Yes.
Ok, merci.
Okay, thank you.
Je disais, d'après notre expérience en
So,
République
based on our
démocratique du
experience
Congo,
in the DRC,
nous avons vraiment,
we
nous sommes passés partout tout en
have
vérifiant ce qui se passe.
gone through
D'après
all
notre
these
expérience en tant qu'avocat
challenges,
en République
and as
démocratique
a
du Congo,
lawyer in the
les
DRC, and
principaux
based on my
défis
experience, the key
juridiques
challenges, the
liés
key
à
legal
l'environnement
challenges
auxquels mon
linked to
pays est
environment to which my
confronté
country is
sont
confronted
d'abord le manque de
are first
sensibilisation
the
de la
lack of
population et de
awareness of the
disponibilité des textes.
population and the
Il y
availability and the
a la
access
rigueur
to
au
the
texte
texts.
qui rime avec la mentalité des paysans. Il faut toujours
So we have
un caractère contraignant parce
to
que
have a binding
jusque-là, il
nature
n'y a
so
pas
that
de
people can
vulgarisation
access
des
to them,
textes.
because now
Les gens ne
texts are
comprennent
not
pas l'importance
spread
du changement
and people don't
climatique.
understand
Donc en
the
RDC,
importance
il y a
of
encore une
climate change.
difficulté
So in the
entre
DRC,
l'État
we have a
et la
difficulty
population.
between
Il n'y a pas
the
de
state
cohésion.
and is that we understand them as an atmosphere phenomena. A climate change is a atmosphere phenomena that happens and occurs, for example, floods, landslides. So we try to explain to the people, giving examples, but the involvement of state is not there. State is not well involved, and this is the major challenge. We have many texts, legal texts, but the implementation is still a challenge, a key challenge, because the government doesn't cover all the challenges. Also, the availability of young lawyers. We don't have specialized courts. It's still a challenge. Some judges do not understand what we mean by climate change. Some judges, we have to ask them whether you understand what we mean by climate change, because we don't have specialized courts. So the government should establish specialized courts that can cover these major challenges to be taken up. Also, the question for me was, what are the measures taken to sensitize the population in the DRC? And what are the obstacles and the challenges facing lawyers. Indeed, we meet very serious challenges because in the DRC, the constitution protects or guarantees to the Congolese a sound and safe and good health, safe environment and good health and good well-being. Also, we have a major challenge regarding the litigations because the litigation is shelved in the offices of magistrates. When you start any case, it is the magistrate or the judge that will decide. And sometimes the victims are not compensated, and sometimes you have just a small compensation, but sometimes you don't even receive it. So in the judges, the litigation is dealt with, but it's really not um, completed. There is no compensation. And when you ask for compensation, you are told that no, you have to wait and wait again and again. Why? Because the judge doesn't know how to proceed, what resolution, what decision I can take for this litigation, which is before me. So sometimes he himself is blocked and he cannot move forward because there is no specialized court cases. So these are the difficulties we encounter in the DRC, and we still need to work a lot to sensitize the population on the necessity to protect the ecosystem, the need to have a sound and safe environment. It is necessary to make advocacies among the population. We indeed make such advocacies, and we make a lot of efforts, and we hope that we are proceeding well. This is our contribution as Mr. Husseini, and thank you very much, ma'am.
Well, thank you so much, Mr. Lambert. It's very interesting to note the challenges that you're facing and climate litigation in DRC. And I've seen one of our participants has pointed out that maybe the challenges that the DRC is facing actually is showing the challenges that Francophone countries generally might be facing when it comes to climate litigation. And it's good to note this because the webinar is on climate litigation generally, even as we speak about the African Court advisory opinion, which we hope will help to shape climate litigation in Africa eventually. It's also good to take notes and to stock take on what is currently going on and how we can change the situation as it is. So right now we'll hand it over to our next speaker, who is Mr. Ayman Chekaroui from Morocco. He's actually going to provide a perspective from a UN representative because he's under the UN. So let's hear from Mr. Ayman.
Hello, thank you. I want to begin by thanking the Pan-African Lawyers Union for this invitation. PALU is doing essential work in building the legal ecosystem that Africa needs, and this webinar is a perfect illustration of that. I am genuinely honored to be part of this conversation. Today is Earth Day, April 22nd, and I want to hold on to that day for a moment because it carries real meaning for this conversation. 16 years ago today, on April 22nd, 2010, Rabat became one of the first cities in the world to host a major global Earth Day observance. It was not simply a ceremony. Her Royal Highness Princess Al Hasna, the chair of the Mohammed VI Foundation for Environmental Protection, presided over that day and used it to announce something unprecedented under the vision of His Majesty the King Mohammed VI, the Morocco's National Charter for the Environment and Sustainable Development, the result of a nationwide public consultative process. That moment, Rabat, April 22nd, 2010, was a statement that ambition must become obligation, that commitment must find legal form. 16 years later, we are gathered to our webinar on climate litigation. The question is the same, the stakes are higher. I should also mention that today, at the very same time as this webinar, I'm attending the 6th Conference of African Ministers of Agriculture of the AAA Initiative in Meknes, in Morocco. The AAA initiative is the initiative for the adaptation of African agriculture launched at COP22 in Marrakesh, which is celebrating its 10th anniversary today. That coincidence of dates on Earth Day is, I think, fitting. The AAA initiative was born inter alia from the same conviction that
de la Convention et l'adaptation africaine de l'agriculture
owed to a continent that did not create this crisis. Something structural is happening in climate litigation. It is not simply that more cases are being filed, it is that a global legal architecture is taking shape across jurisdictions, across mandates, across legal traditions. And we must be clear about where Africa stands in this picture. Africa currently accounts for less than 1% of global climate litigation, a couple of dozen of documented cases to date. But the field is nascent, it is, however, accelerating. The question before this room, a virtual room, is not whether climate litigation will grow in Africa. It will. The question is how to build the conditions for it to grow effectively. Global frameworks do not directly bind regional courts, but they supply the normative raw material that judicial reasoning turn into enforceable obligations. And right now, the process is accelerating. Through the advisory opinions of ITLOS, the Inter-American Court of Human Rights, and the International Court of Justice, and the African Court process underway, a remarkable convergence is emerging. Different mandates, different jurisdictions, yet increasingly consistent conclusions around the same core principles: due diligence, prevention of transboundary harm, and the duty to cooperate. These are not isolated opinions, they form a trilogy, different jurisdictions with a single converging legal narrative. International law is clarifying itself. But the real question, especially in Africa, is how this legal clarity translates into cases, into arguments, and into decisions on the ground. For Africa, the opportunity is not to simply receive these norms from the outside. It is to contextualize them, to shape their application through the lens of development realities, climate vulnerability, and equity. And it is not abstract. In Morocco, in 2011, Morocco enshrined the right to a healthy environment and sustainable development directly in its constitution, Article 31, making it one of the first countries in the region to give this right constitutional status. That domestic commitment translated into international leadership. Morocco was one of the 5 co-presenting states, alongside Costa Rica, the Maldives, Slovenia, and Switzerland, of the landmark resolution adopted by the United Nations General Assembly on 28th of July 2022, recognizing the right to a clean, healthy, and sustainable environment as a universal human right. A right that Morocco, as I mentioned, had enshrined in its constitution over a decade earlier, had now become, through sustained, concerted diplomatic effort, a universally recognized human right. This is the arc this conversation is part of, from national constitutions to regional charters to global recognition to litigation. This is where the work of the IUCN World Commission on Environmental Law becomes critical. As a global network of over 1,400 volunteer legal experts from more than 170 countries, judges, professors, government officials, practitioners, and scholars, WCEL plays a bridging role, ensuring that emerging jurisprudence does not remain theoretical through judicial capacity building, legal guidance, and cross-regional dialogue. This work has been particularly visible in 2 recent gatherings in which I had the pleasure of playing an active role. The first was the 4th IUCN World Environmental Law Congress, which the Hassan II International Center for Environmental Training hosted in May 2025. The first time in history that this global congress was held fully on African soil, with more than 200 speakers, more than 1,000 people taking part for 3 days of roundtables, plenaries, and parallel sessions covering and spanning every domain of environmental law. The Congress team, integrated legal protection of air, ocean, and land, was not chosen arbitrarily. It reflects a fundamental diagnosis of where international environmental law stands today. Rich in principles, fragmented in application. Air law, ocean law, land law, climate law, biodiversity law. Each has developed its own institutional architecture, its own treaty regimes, its own negotiating communities. And yet the planet does not operate in silos. Drought affect land, water, and the atmosphere simultaneously. Ocean acidification is a climate problem, a biodiversity problem, a food security problem at the same time. The legal response cannot afford to remain compartmentalized when the ecological reality is inherently integrated. The proceedings produced a central conclusion. The effectiveness of environmental law today depends not on the quantity of legal instruments. There are already approximately 1,500 multilateral environmental agreements in force, but on their coherence, their mutual reinforcement, and their integrated application. Fragmented governance is not a technical inconvenience. It is a structural failure. In my address as Deputy Chair of the Commission and Director of the Center, I put forward 4 concrete recommendations. Promoting cross-cutting environmental impact assessments that account for land, air, and ocean interlinkages, enhancing interministerial and interagency coordination to break institutional silos, advancing regional and international cooperation through existing frameworks, and updating legal and regulatory frameworks in line with the latest scientific knowledge. They are not abstract principles. They are operational imperatives, and they apply to Africa, where integrated governance frameworks are urgently needed and unevenly developed. The second was the International Conference on Climate Change Advisory Opinion, held at the University of the West Indies Cave Hill campus in Barbados in March 2026. It brought together practitioners, scholars to examine the 3 issued advisory opinion, ITLOS, the Inter-American Court, and the ICJ, and the pending request at the African Court on Women and People's Rights. The very opinion this webinar is anticipating. The Barbados Conference produced a conclusion I carried directly into this room. The advisory opinions have provided legitimacy and legal clarity. But as Professor Christina Voigt, chair of the IUCN Work Commission Environmental Law, noted in her closing remarks, that clarity cannot replace the political decisions that must now follow. Legal clarity without political will and institutional capacity is a framework without a building. And that gap is consequential in Africa. For African lawyers, this means something very concrete. These advisory opinions are not abstract texts, they are tools. They provide arguments that can be invoked before national courts, regional bodies, and even in administrative proceedings. Climate litigation is no longer a conversation between states and court. It is expanding rapidly and deliberately into the private sphere. We're seeing a clear and structural shift towards shared accountability. Cooperation, financial institutions, and entire supply chains are increasingly brought within the scope of legal responsibility. This reflects a deeper truth about climate change. Emissions, risks, and impact are distributed across entire economic systems. You cannot hold states alone responsible for what entire economies produce. In this context, global initiatives such as the United Nations Global Compact or the Marrakesh Partnership for Global Climate Action, launched in Marrakesh in 2016, which formalized the sustained and structured engagement of non-state actors, cities, business, civil society in the UNFCCC process, play an important role that is more significant than their voluntary nature might suggest. They contribute to defining what responsible corporate conduct looks like. What is emerging gradually but unmistakably is a normative framework for corporate climate responsibility, even in the absence of a single binding global instrument. And a model at work is one that brings together public actors, private sector partners, civil society, and youth around a shared operational agenda. Accountability in this framework is not adversarial, it is co-constructed, and this is what the Foundation has demonstrated. But I want to go beyond accountability, because the most powerful response to a climate crisis is not only legal, it is generational. And this also reminds us of something essential. Litigation is not the only pathway to accountability. Building capacity and solutions on the ground is equally, if not more, critical. The Mohammed VI Foundation for Environmental Protection and the leadership of our Highness Princess Al Hasna has built 3 African initiatives that place youth at the center of climate action on the continent. The African Youth Climate Hub, launched at the UNSG Climate Action Summit in 2019, connects and supports young African climate entrepreneurs and innovators across the continent. Since its launch, 3 editions of its incubation program have supported 30 projects from 14 African countries, delivered over almost 2,000 hours of training, created more than 200 green jobs, and seen cohorts generate nearly $1 million in revenue within 6 months of training alone. And just last week, a new cohort of 10 projects began their incubation in Rabat. The work continues on the ground right now. The African Green Universities and Youth Education Network is embedding sustainability science in the DNA of higher education institutions across 14 African countries and 40 universities. And a hybrid tutored program for capacity building in oceanography for young Africans registered and as a voluntary commitment under SDG 14, combined online training, laboratory internships, and at Morocco's National Institute for Fisheries Research, and live oceanographic expeditions to equip the next generation of African ocean science practitioners. These three initiatives share a common conviction that the most durable climate action is the kind that young people design, own, and lead. Africa's youth are the answer. Now, when it comes to the biggest gap between international commitments and actual implementation, I think this is a particularly important question. And the answer is clear. The gap today is not ambition, it is execution and accountability for delivering it. But let's be more precise about where the gap actually lies, because the framing matters enormously. Too often, the implementation deficit is presented as a problem of recipient countries, insufficient capacity, weak institutions, inadequate project preparation. There is truth in that, but it is incomplete and, frankly, an unjust framing. Africa, as we all know, contributes less than 4% of global greenhouse gas emissions, and yet it bears a disproportionate share of the consequences in droughts, in floods, in displacement, in food insecurity, in coastal erosion, etc. This is not a technical problem, it's a moral one. Africa is living with a climate injustice it did not create. We heard this stated with clarity at the closing plenary of COP30 in Berlin. The African group of negotiators expressed deep concern that essential language on means of implementation, finance, technology transfer, and capacity building had been significantly weakened in the final outcomes. The chair, Dr. Richard Muyungi, described Africa's stories in terms that deserve to be repeated in every forum where this gap is discussed. The daily struggle of farmers facing unpredictable rains, of coastal communities watching the shoreline recede, of children growing up in regions where drought and flood now shape the calendar more than seasons do. He went further on the global goal on adaptation. He acknowledged the progress made, the development of a coherent set of indicators offering a common language for understanding resilience, but was unsparing about its limits. Indicators alone could not protect a family from rising waters or yield harvests during a prolonged drought. Without means of implementation, the risk remained elegant words on paper. And on national adaptation plans, he was direct. For Africa, NAPs are not administrative documents, they are lifelines. When they remain unfunded, it is not a gap on an agenda item, it is a missed opportunity to safeguard communities living each day on the edge of climate extremes. These are not abstract challenges, they are the exact barriers that practitioners across the continent identify every day. Legal frameworks that need to be strengthened, limited access to justice, insufficient climate data, and resource constraints that make litigation a distant prospect for communities who need it most. Closing these gaps is not only a policy imperative, it is a precondition for climate litigation to function as a genuine tool for justice in Africa. That is the first and most fundamental gap. Global North accountability. Developed countries have consistently fallen short of the climate finance pledges. The 100 billion commitment made in Copenhagen took more than a decade to approach. Adaptation finance remains chronically underfunded, and access to what finance does exist, to the Green Climate Fund, the Adaptation Fund, bilateral investment, the more recent loss and damage fund, remain burdened by accreditation requirements, procedural complexity, and timelines that bear no relationship to the urgency on the ground. That must change, not as a matter of generosity, but as a matter of legal obligation. The second gap is biodiversity finance. The Kunming-Montreal Global Biodiversity Framework set ambitious targets, but the financial architecture to deliver those targets remain dangerously underdeveloped. This cannot be separated from the climate conversation. Ecosystems are both carbon sinks and adaptation infrastructure, and treating them as a separate budget line in itself is part of the problem. The third gap is ocean finance. Last June, at the third United Nations Ocean Conference in Nice, Her Royal Highness Princess Leila Hasna, representing His Majesty King Mohammed VI, co-chaired alongside President Macron the Africa for the Ocean Summit, a landmark gathering of African leaders dedicated to Africa's maritime future. The royal message delivered on that occasion was unambiguous. Africa, with over 30,000 kilometers of coastline and 38 coastal states, must move from acknowledging the value of its marine resources to actively safeguarding and developing them. The BBNJ agreement, which entered into force a few months ago, is a genuine milestone for ocean governance, and Africa was central to securing it. But a legal framework without financial architecture is a promise without delivery. UNOC 3 generated momentum. What must follow now is finance, concrete, accessible, and proportionate to the scale of what is at stake. And yes, alongside all of this, capacity gaps on the ground are real. Many territorial and local actors lack the technical tools to operationalize what has been agreed internationally. Fragmentation between science, policy, and implementation persists. Project pipelines are not structured to access available finance. These are genuine obstacles, but they exist within a system that is in itself inequitable. Fixing the pipeline without fixing the tap is not a solution. The world does not lack commitment, the world lacks systems and the political will to make those systems fair. Going forward, three strategic avenues stand out for Africa. First, strengthen foundations that are both legally robust and contextually African. Second, cases targeting procedural obligations, participation, access to information, and transparency, where the evidentiary bar is not as high and the potential impact remains high. And third, litigation that links climate impacts directly to concrete economic and social harm, loss of livelihoods, destruction of food systems, where the human story and the legal argument converge more powerfully. Let me close by connecting several questions and points. Law is clearer than it has ever been. Advisory opinion are hard-earning customary obligations. Corporate accountability is no longer a theoretical proposition, and the commitments on paper from Paris to Kunming to the various COP decisions are substantial. But legal clarity alone does not protect our forests. It does not finance a coastal adaptation project. It does not deliver climate justice to a continent that has done the least to cause this crisis and is paying the highest price for it. If climate litigation is to grow in Africa, it will not be because of legal theory alone. It will be because lawyers, judges, and institutions are equipped to use the law as a practical tool for justice. This is the work that Palu is doing, and this is the work that this webinar is part of. The next phase of climate law is not about defining principles. It is about making them work equitably, with adequate finance, and with honest acknowledgement of who owes what to whom. And so I return to where I began. Rabat, April 22nd, 2010, a city and a country that chose to mark Earth Day not just with a statement, with a charter, not just with ambition, but with obligation. This is the standard. 16 years on, it remains the challenge. The future of climate litigation will not be decided only in court terms. It will be determined by our collective ability to translate legal clarity into real-world transformation at the territorial level, with the actors who bear the consequences, and through institutions capable of bridging the gap between what has been promised and what must be delivered. Thank you.
Oh, thank you so much. That was Ayman Chekarui from Morocco. I can't really remember the name of the institution, but he represents the UN, and he's just given us a global perspective on climate litigation from beyond Africa and within Africa. And at this juncture, I would like to open the floor. If you have a question, kindly raise your hand up, and we'll allow you to speak. And I've seen that there's some questions in the Q&A. But I also just want to highlight some of the things that Ayman has said. It's very interesting to note that some of the things that you're talking about, it's interesting when he said that you cannot fix the pipeline without fixing the tap, and that the fact that everything that you're doing on behalf of the environment, climate change, and human rights does not end in the courtroom. There's so many activities that we still need to do. There's so many actions that go with litigation. Litigation alone is not the solution. So that's amazing. Emmanuel Opoku Awoko, would you like to unmute and speak? If not, then I'll just read. If you'd like to speak, I will just raise your hand and then we'll unmute and allow you to speak. So at this juncture, I'll just read the question as it is in the Q&A. Emmanuel is asking, how are courts increasingly being used to connect climate change with human rights, environmental protection, and government accountability, particularly in reviewing state policies, challenging fossil fuel projects, ensuring meaningful public participation, and holding corporations liable for environmental harm. Maybe Wendy, you could take that. And then the next question is, in a situation where a government, the next question is from Mark Numbo Boy. In a situation where a government is unable to control development in respect of the construction of houses, both for residential or business, which said construction ends up blocking waterways and thereby causing floods, which otherwise sometimes leads to loss of lives and property, is it the government that should be held accountable for any such losses, or the private individuals who engaged in any such unlawful construction? That's a very interesting question. Lambert, would you be kind enough to take that question and respond to it? And then the last question in the Q&A is Hamani Asomani. That one, I'll allow Lambert to read it and respond to it. I'm not exactly a French speaker. I've also seen some hands raised. Onesmo Daud, would you like to go first? And then Sarah SL. Onesmo. Onesmo Daud. IT team, kindly unmute Onesmo Daud to speak. Yes, you can now unmute and speak. Onesmo?
Yes.
Yes, please, we can hear you.
Good afternoon.
Good afternoon.
Yes, my name is Onesmo Mesudaudi. I'm a lawyer from Tanzania, Human Creation from Tanzania. First of all, thanks for giving this opportunity for asking some question based on this topic, climate change, climate litigation in African and special African advocacy opinion on human rights obligation of the state on climate change. So my question is directed to previous person who present well, and I appreciate the presentation is going well. I have two questions. First question is, how is climate litigation involved in African compared to other regions such as European and Latin American? That is the first question. And the second, what make human rights-based climate litigation particularly relevant in African context? That is my question. Thanks for listening. And I come from Tanzania Human Rights Defenders. I'm a lawyer.
Thank you, Onesmo. Kindly repeat the second question, if you don't mind, please.
Yes. My second question is, what makes human rights-based climate litigation? Are you together?
Yeah.
Yes. Human rights litigation, in particular, relevant in African context.
Okay. Thank you very much.
Okay.
Thank you very much. Next, we have Rodolphe Bodin. I hope I pronounced it correctly. Kindly unmute and speak. Rodolphe. Okay. Kwame, if you're ready, kindly go ahead.
Am I audible, says Rodolphe? Am I
Yes.
audible?
Yes, we.
Thank you very much. I tried to unmute, but I couldn't. First of all, I would like to thank everyone for their presentations, and also I'm introduce myself. I am Rodolphe Attai. I'm a jurist, specialist, expert in climate right. I have two concerns. The first one is relating to the cooperation mechanism for technology transfer, which is generally provided for in international treaties in terms of protection of environment. So how don't we see it in reality? So what justifies that we cannot see them materialized in reality, especially in terms of technology and environment, quantification of data, measurement of application data? We can see that African countries are lagging behind in acquiring such technology. Also, my second question is relating to the availability of funds, how to have a financial cooperation between African states and the countries of the South, Global South, which are the less polluting ones. So what delays funding? When we ask this question, we are interrogating why we don't have a developed industry and we are not the major polluters. So the responsibility is considered as common, but we are the less polluters. These countries do not pay their share of subsidies to the less polluting countries so that they can adapt to climate change. Why don't we distinguish the more polluting countries from the less polluting ones? Thank you very much.
Thank you so much. Thank you so much, Rodolphe. That is a very important question. I think you're trying to talk about climate adaptation, climate finance, and the doctrine of common but differentiated responsibilities applied in trying to get our climate solutions. So I'll allow Kwame and then Emmanuel Opok, and then we'll take it back to the panelists. Kwame, please unmute and speak, and then Emmanuel Opok. Kwame, if you can hear me, kindly unmute and speak. Okay, Emmanuel, kindly unmute and speak. Emmanuel, if you're speaking, we can't hear you. Okay. All right. Let me just allow this panelists to respond to the questions that have been raised. I'll let you, Wendy, go first, and then next, Mr. Lambert Husseini. Yeah, just pick any question that you feel like you want to respond to and respond to it. Thank you.
All right. Thank you so much for the questions. I'm just going to answer one at the moment and then give my fellow panelists a chance to also answer, and then we can just interchange like that if that's okay with you. So I would like to answer the first question that was presented in the question and answer section, which my short answer to is, courts are being used as sites of climate governance. They are connecting climate change to human rights by translating the rights that we have to life, to health, to dignity, participation, and the substantive environmental right into enforceable duties. So they're linking climate change to environmental protection by insisting on climate sensitive EIAs and lawful environmental decision making. They're also reviewing state policies, licenses, and exemptions for legality and accountability. The courts are also ensuring meaningful public participation and access to information through climate change litigation. They are extending accountability to corporations, especially in fossil fuel and extractive sector. So the role of the courts then is no longer just corrective, but also increasingly constitutive of climate governance itself. I hope I've answered your question. Thank you.
Thank you so much, Wendy. Lambert, would you like to respond?
Thank you very much, madam. I would like to answer to the question raised on human rights facing the environmental litigation and climate change. I would like to answer and say that what we should understand first is that the world is experiencing atmosphere changes that will have consequences and impact on human life. And man, human being, is at the core of climate change. He is the main stakeholder before even industries, because it is human being that transforms the material. It's man who builds industries. So we should first train human being and man, because revolution starts with man. Man should be at the core, at the center of climate change, because it's him who acts first. So we should understand that today the litigation should start by man. Personal implication and engagement is very important. Even if there are some countries who are less polluting and other countries who are more polluting the earth, the climate, there are landslides, but a human being is also there. Even in less polluting countries, population and man could create a situation where climate change will happen with charcoal, and even today there are some handicraft um, industries that appear even in the DRC. Companies do not know how to manage waste and pollute the environment. So the contribution of each one should make sure that the human being is at the center. Human being should be engaged together with the government, because the government supports, but everybody should be involved, because climate change today is a global issue involving everyone. So everyone should be engaged and involved. All actors, political, legal, jurists, anyone who is a living being needs to be engaged in these issues of climate change and the atmosphere problem, because all affected. Whatever you are in a less polluting or a more polluting or polluted country, you need to work on this issue and sensitize and mobilize and inform your neighbor so that he understands that what is requested is the engagement and involvement of everyone, because human life is impacted by climate change. This is what we can add as a contribution to this question, the question which were raised by the participants. Thank you very much.
Thank you so much, Lambert. I can see there are other questions raised in the chat, but I'd also like to respond to something that Rodolphe raised on climate adaptation, the fact that there are some commitments that were made through treaties in terms of technology transfer and climate finance that was supposed to come to Africa. But we're not seeing this being materialized. We're not seeing the availability of funds for climate adaptation and mitigation. What do you think is the problem with this? What do you think is going on? And Wendy did point out something that is unique, and that is why when you talk about the the advisory opinion that we requested at the African Court, one might say that the International Court of Justice has already rendered an advisory opinion. So why would we feel the need to go again to the African Court to request an advisory opinion on behalf of Africa? Well, the one thing is for sure is that the Inter-American Court, the International Tribunal on the Law of the Sea, and even the International Court of Justice, despite all those advisory opinions, there are still some gaps that have not been addressed. Some of those gaps are some of the things that we have brought out in the request for the advisory opinion at the African Court on Human and People's Rights. For example, how can Africans or African countries lead in the process to clean energy? How do we make the just transition truly just? And also, when we talk about climate finance, it was supposed to come to Africa as a matter of right, but that is not happening. We're getting climate finance in terms of loans. So the global north countries, or the global north countries have utilized this, as a weapon to once again bring loans to Africa. African countries are drowning in loans. So where did we go wrong? Because when we sat down and came up with those treaties, agreements, resolutions, heads of states, they go there and they do all the talking. But when we come out empty-handed. Things are said, but they're not done. And I'm also looking at the question that Betty Sungura has raised on, does Africa really get a fair or maybe a good deal from the Conference of Parties negotiations that happens every year, in your view? And it's so interesting to note that when these things happen, whether it's in Brazil or Dubai, or the next one is in Turkey, our governments send very many people. You find that even 20 people, a delegation has 20 people. Like, for example, I come from Kenya, you might find even 20 people, 30 people going for those negotiations. But when they go there, they have other agendas. So we don't really get out of the COP with much. It's just usually too diplomatic, too reserved. Because even when you look at the Dubai COP, which happened, I think last year, but one, when people went there, some were negotiating fossil fuel deals, and people are there for the Conference of Parties on climate change. So it is very difficult, to understand some of these things and why they're happening. But I will move to the next question, and that was raised by, no, Judith is saying that it is true that litigation alone is not sufficient. In many African countries, court processes can be lengthy and slow to conclude. There is therefore a need to complement litigation and other approaches such as community empowerment and advocacy to achieve more effective and timely outcomes. That is very true. There are also some French comments, which I will just take a few minutes to translate, and then I'll read it out. Dr. Getahun A. Mosisa is saying that, good afternoon, everyone. Thanks for Palu for organizing this event. My question is, as you know, land is a very critical resource for socio-economic development of the continent, and even for some, the sole indispensable source of investment. This makes authorities, such as the executive, to be anxious and suspicious of any land-related environmental litigation as disruptive attempt than as a quest for rule of law, human rights, and justice. This affects the quest for accountability in the sector. What can be done, especially by lawyers and development practitioners, to change these detrimental negative perceptions of state authorities in the continent? Any of panelists can respond to that. And there's also another French speaker. Because I'm the moderator and I'm not exactly a French speaker, kindly, if you could unmute and speak, that will be great. Wendy is asking, how do you join the committees? I'll share the email.
Thank you. Thank you. It's Lambert Rossini.
Okay.
So all what we should do, the lawyers should make some advocacy towards the government because they are the one who are close to the population. They are also close to the government. So the lawyers should not get tired in a certain way. They should maybe work towards making more advocacy rights to the government, try to remind them the laws that are implemented related to environment. So this is all what the lawyers should do because today we have governments who don't really understand the situation. We don't have enough implications. You will see politicians who are not really committed as far as climate issues are concerned. But when funds are disbursed, you will hear people say, okay, they disbursed $20 million, $100 million, and even billions who that were disbursed. But at the end, we don't have any impact on the in the field. They will say, no, we need this for the climate change issue. And here in the Democratic Republic of Congo, it's just music, you know. And this also happens in various African countries where you will see that a certain amount was disbursed and the government communicates about the amount of money, but usually or generally, this amount of money doesn't correspond or doesn't answer to the needs of the needs that need to be taken into account. And most often people even divert that money, and at the end, we don't really progress. So this is what the government should do. They should be more committed and also raise awareness in order for everyone to join their efforts because this issue is a matter of everyone. Thank you.
Thank you, Lambert. Wendy, would you like to respond to any of the
Yes.
questions?
I just want to respond to 3 questions for now. So the first one is from Mac Numbo Boy. I don't know if I'm spelling your name correctly. That was asking about accountability for floods and illegal construction. So in scenarios where there's unchecked construction which blocks waterways and causes floods, the liability will be shared between private individuals, those are your non-state actors, and the state itself. So regarding private liability, the individuals who engage in illegal construction, which is the building in water channels or wetlands, or without planning permission, are directly liable for for the damage that their structures then cause. And then there is government liability. So the government, be it in the form of the municipality, the town planning departments, they will be largely to blame for failing to enforce building codes, for failing to maintain drainage, and for illegally approving developments in these flood-prone areas. So in the legal action, the victims can sue both the illegal developers and the municipality or the government or the state. So that is the first question that I wanted to respond to. And then the second question I want to respond to is on the Conference of the Parties, climate summits. So yeah, it's a bit difficult. We cannot discredit how important these are because they are the main global forums for addressing climate change. However, the deal, we might say, is a bit, as it stands now, it's a bit poor for Africa, I would say, in my personal opinion, because of a number of reasons. So, for example, insufficient finance. So while the developed nations were pledged about 300 billion annually by 2035 at COP29, it's far below the estimated 1.3 trillion that developing countries need. There's also minimal investment, wherein Africa receives less than 1% of global climate finance annually. There's also the problem of debt-based funding. Much of the climate finance that is flowing into Africa is in the form of loans, which then increases the fiscal stress on African nations rather than being debt-free aid. Developed nations, they also often push for focusing on critical minerals in Africa, which is needed for their own green transition, rather than providing the adaptation finance that Africa needs. So there's need to move from promises to tangible action and funded projects. There's need for prioritizing funding for climate resilient agriculture, for example, and infrastructure, rather than only focusing on mitigation. And building local value chains for critical minerals rather than just exporting raw materials to avoid the resource curse. So in short, I would say the COP summits are necessary, but at the moment they're largely ineffective, an ineffective stage for Africa, which is struggling to shift from being viewed as a victim to being a player in climate diplomacy. And then the other question that I would want to respond to is the one that was asking the relevance of human rights-based climate litigation, why that is particularly suitable for the African context. I would say that is also for a number of reasons. So there's the reason that of disproportionate vulnerability, where as has been, the rhetoric in this conversation, that we are amongst African communities are amongst the most impacted by climate change, yet we contribute the least to these global emissions. So human rights, especially the right to life and dignity, allows these communities to demand protection and compensation. Many African nations also have progressive constitutions that guarantee environmental human rights. For example, Section 24 of the Constitution of South Africa, which makes it then important or a bit easier, as you would have it, to use these constitutional environmental human rights and climate change litigation, because that is the language that we are mostly used to, and that is also very applicable in human terms, that we can see in human terms, and very applicable to us. And then there's also the African Charter, which provides a strong basis for litigation. Again, the Section 24, which is the right to a general satisfactory environment, as well as Article 22, which is the right to development. Human rights arguments, they also allow litigants to link local environmental pollution, things like gas flaring, for example, directly to climate change impacts, as we saw in the, I don't know if I'm pronouncing this correctly, I would say Bama versus Shell case in Nigeria, but it's spelled with a G. But yeah, that case. And then human rights frameworks also provide the specific tools to defend the rights of children and indigenous people, as well as displaced persons, as we saw in the Ogig and the Royce cases. Yeah, So I would say that is the importance of the relevance rather of using a human rights-based type of climate litigation in Africa. Thank you.
Thank you, Wendy. And I want to hand it over to Richard. I can see your hand is up. At this time, I've also just seen a question by Fernand Guevara. Okay, Richard. Okay, let me just. Okay.
Thank you, John Cynthia, for giving me the floor. So I want to come back on the concern of Ms. Osemo, who asked how the climate litigation implies Africa compared to the United States and Europe. So here, I would like to come back on our goal, the goal of this webinar, which consists in presenting the trends, the key trends in the world and in Africa. And as an expert in environment issues, I would like to uh, give an answer and not to go into the details. So I would like to say that as regarding the climate conflicts, there are trends, various trends in Europe and in the United States. In the United States and in Europe, it's almost the same trends, but it's not the case in Africa. So in order for us to better understand, I would like us to put in mind that we are dealing with the various features. So we have to deal with the North, we have Europe in the United States, and in the South, we have Africa. And the main goal, we have the main goal, the main actor, the main argument, and the main target. So regarding the main goal, regarding the main trends, we are dwelling on the reduction of emissions, whereas in Africa, we are working more on resilience and the survival. So we are trying to talk about adaptation. So it's up, it's all about survival, as I said, but who is the one in Europe? We have non-governmental organizations, civil society organizations, whereas in Africa we have public organizations, prosecutors. We have, as uh, Mr. Husseini said, some files are completed in less files are sent to the court. So regarding the key arguments, in Europe and in the United States, we have diligence, the due diligence. And I talked about it during my opening remark. And the science here, the International Court of Justice tried to lay an emphasis on it. And they talked about the Jack group, and scientifically, it's all the states should subscribe. But regarding Africa, the resource or the source of law regarding this litigation is social justice and constitutional law. So we have various actors at the level of the United States and Europe. We have states, and in Africa we have deforestation, and you see that we also have different interests related either to Europe and the United States of or Africa, and we already see some trends. So this being said, I would also like to come back on the concern of Usman Dogome. I don't know if I pronounce his name right. So he asks if or when, if the climate litigation, and he insisted on displaced persons, if these litigations can be solved by I mean, he wanted to know what is the base. I think the base here is the Constitution. The Constitution is imposing a good environment, the right to the health, and the right to live. So, thanks to these arguments, when people move from a place to another, we have droughts, floods, etc. They find a solid mechanism, a legal tool, which is like the constitution and the mother of all the laws in each country. And at the level of Africa, we have uh, the Human and People's Rights Charter. So the problem now is who is taking the initiative to claim, and if no one does it, then uh, nothing is done. So that's the reason why we should raise awareness and educate people so that when they are victim of climate change, they should know to whom I mean to whom to submit their claim, you know. So this is where we have the problem. The fundamentals are already there. Now I would like to finish with the concern of Mrs. Dorcas. This, she says, how can we solve climate injustice? I will uh, I will say it cannot, I mean, we have various types. So each litigation, climate litigation, is specific. Some can make a claim after pollution, for example, of mining companies. Some can make a claim after a deforestation issue. Some can make a claim after environment issues related to hygiene, for example. So each case is specific and should be solved in its specificity. So these are some answers that I had to provide in addition to all what the colleagues also shared as a solution. And I would like to commend their various interventions. I also commend the presence of all the participants because I'm following everything, and we are more than 100 participants since the beginning. Thank you. This is commendable.
Amazing. Thank you so much, Richard. You have really saved me there. My French is not so good, so thank you so much for responding. That is our Environmental Law Committee Chair who has helped in responding to some of the questions. And if Wendy or Lambert would like to say something, I'll just read the last comments and the last questions, and then you can give your closing remarks. If you'd like, you can make it as powerful as you want. So I'd also like to take this moment to recognize our Deputy Secretary General, Miss Nadej Kimba. Bonjour, welcome. Thank you for joining us. Really amazing. Thank you all for staying this long in the webinar. Honestly, thank you for the engagement. Thank you for all the questions, all the comments. This is amazing. We are going to be doing a series of climate mitigation webinars this year. And so this is the first one. And so kindly just be on the lookout for the next one. So I'm seeing Fred Aparo is saying, given the likely persuasive but non-binding nature of the anticipated African advisory opinion, how can litigants concretely leverage it to impose enforceable obligations on states, particularly in jurisdictions where courts are traditionally deferential to executive policy on climate and development? And also, is there a risk that the African advisory opinion will remain largely symbolic unless regional courts are willing to reinterpret state obligations under the African Charter on Human and People's Rights to include enforceable climate duties, and what jurisprudential shift will that require? I'd really love to hear your thoughts on that, Wendy, Lambert. And also, Dede Enyonam is saying Africa has the minerals which the West needs. If they are not forthcoming with the climate finance funds, our leaders should ensure that any mining done is done with technology that minimizes pollution and engage in projects that sequester or reduce emissions. Our leaders should actually be committed to reducing emissions. That could be followed with legislation, which should be enforced fiercely. Thank you so much. The last one is from Fernand Guevara, Mekongo Mbala. How influential will the advisory opinion of the African Court on African countries or how influential will be the advisory opinion of the African Court on African countries if we bear in mind that only a small minority of African countries effectively signed the protocol recognizing it? And that one I'd just like to respond to that directly is that the advisory opinion is not contentious litigation. It's an advisory opinion. And so it's just going to basically highlight or elaborate further on the obligations of states under the African Charter. So that as long as you're a signatory to the African Charter, and that means right at the moment, I think it's around 54 or 53 countries that are signatories to the African Charter. And so it applies to all of them. So the way the court interprets that then applies to all of them. And so that is why the advisory opinion is actually a good avenue to go through because, as you said, some countries cannot be sued under the African court because they have not deposited what we call the Article 34 declaration of the protocol of the court, so that allows them to be sued by individuals or civil society. So at the moment, it's very, very limited in that regard. So, but the advisory opinion applies to all of them, although it's not binding, but we have a lot of work to do regarding the advisory opinion once it comes out. So I'll allow Wendy and then Lambert to just respond to some of the comments and some of the questions, and then as you give your closing remarks so that we can finish on time. Thank you.
Thank you. I'm just going to respond to the question on the non-binding nature of the advisory opinion, how to leverage it for enforceable obligations and the risk of symbolism. So yes, it is non-binding. The advisory opinion will be non-binding. But it is poised to act as an authoritative interpretation of international and regional law that litigants can then leverage to impose enforceable obligations on African states. So they can transition this opinion from a persuasive tool to a binding obligation through concrete strategies, particularly by integrating it into domestic litigation and administrative processes. For example, litigants can argue that the opinion sets the minimum due diligence standard required for states to comply with the African Charter, and failure to meet this standard, for example, by authorizing fossil fuel projects without adequate impact assessment, becomes then an internationally wrongful act that the domestic courts must restrain, as noted in similar 2025 ICJ analysis. They can reinterpret development and sovereignty. So in jurisdictions with high executive difference, the activists can use the advisory opinion to argue that state discretion is limited by human rights obligations. It can be used to challenge policy that causes environmental degradation, arguing that development cannot come at the cost of existential risks to citizens. They could also use regional and international interstate claims. So while the opinion is non-binding, it can provide the legal basis for contentious cases before the African Court or other tribunals, which then forces states to act on mitigation and adaptation to avoid liability. The opinion can also be used to hold states accountable for not regulating the conduct of third party, such as multinational corporations, therefore creating a legal duty to regulate mining and extraction. Then regarding the risk of symbolism, yes, there is a substantial risk that the opinion could remain largely symbolic. For starters, it is asking a lot of things, to be clear. Not that they're allowed because they're irrelevant. All of those questions are relevant that have to be asked. But I really hope that the African court can engage with them with regional specificity, so that they don't remain largely symbolic. And then the many domestic courts, for example, looking at executive deference, many domestic courts traditionally defer to the executive on matters of climate and development, viewing climate action as policy making rather than law enforcement, which is also something that can risk it being symbolistic. But then they are required, jurisprudential shifts that to make the opinion enforceable, the courts would need to undertake a significant evolution, jurisprudential evolution, specifically regarding the African Charter. So they could do this with the substantive interpretation of Article 24, as I mentioned already, evolving derivative rights. So the courts must, try to explicitly link Article 24 with, for example, the right to life, the right to health, which creates a direct nexus where environmental damage equals a breach of these fundamental rights. They can also do this by acknowledging the right to participation, transparency, and accountability in climate-related decision-making, and also applying extraterritorial obligations. So this is shifting jurisprudence to recognize that, African states have a duty not only to protect their own environment, but also to demand action from global high emitters, which strengthens then the legal stance for climate justice. So these will be some, I would think, of the required shifts so that the African opinion does not run the risk of symbolism. Thank you.
Thank you so much, Wendy, for that intervention. And then thank you for your closing remarks, Mr. Lambert.
Thank you very much. Thank you to all the leadership of Palu. I think that everything was said by the previous speaker, especially what you wanted to say, and Article 24. So everything was said. What we can add is only to thank the committee. I can see here the Vice President of the PALU, Madame Nadej, and also thank everyone for their engagement. In fact, the advocacy should not be only internal. We propose an international advocacy led by PALU by promoting and protecting the environment. So, because Africa really needs a major advocacy domestically and also internationally. I would like to thank you for your time dedicated to this webinar, and also for moderating this webinar. Indeed, it's for us an honor to be part of it. And since you said that this webinar will be ongoing, then we hope that this issue will be also on top of the agenda, because everybody is concerned by climate change. This is my last words, and I would like to thank all the speakers, the panelists, the moderator, and thank you to the whole team.
Thank you so much. Thank you, Wendy. Thank you, Lambert. Thank you, Richard. Thank you to all our participants. We really appreciate you. Now, the discussion will not end here. As I mentioned, we'll continue the discussions we'll continue the series on climate litigation, and we'll continue discussing climate litigation in Africa and beyond. And we hope that you join us and we continue. And I'll just give this moment to Ms. Nadej Kimba, maybe in 1 minute to say something, and then we can close completely. So we're closing. So Nadej, you're welcome.
Can you hear me? Says Madam
Yes.
Nadej.
Yes, we can hear you.
I would like to greet all the participants. And as I said in my message, I would like to hail and greet this initiative and welcome it. It is a challenge where everybody should feel involved. And we need a group of lawyers that can sensitize the others to understand the importance of climate change and also to show the way forward. It is a challenge of the impact of human being on nature, and it really it is expanding. So I would like to thank your initiative, and I hope that we will continue such webinars to enable more sensitization and also to try to find a good way forward for the future. Thank you very much, Madam Moderator. Thank you, all the panelists. Thank you to the President. I thank everybody, in fact. Thank you so much.
Thank you so much, Nadej, for that. Thank you, everyone, for staying for the whole time. Thank you for participating. Thank you for your contribution. Just to remind you all and our members and everyone who is interested, our annual conference is coming up where we usually meet and have more conversations on such topics. We'll definitely have a segment on climate litigation in Cairo, Egypt, from 31st August to 2nd September. So kindly, you just make plans and we'll see you there. So I've also shared the email that if you have any questions, the email that you can make inquiries on is in the chat. If you have any question on the annual conference. Thank you so much once again, our panelists, Madam SDG, our chairperson. Thank you so much, everyone. See you next time. Bye. Au revoir.
Bye. Thank you, Joan, Cynthia.
Bye. Thank you, Wendy.
Bye.
Bye, Richard. Thank you. Thank you, Lambert. Bye.
Bye. Hello. Yeah. Option unaweza ukaona kwenye hicho sasa, tunaweza kusema contract extension, wana allow viewers to recover also.